Hey out there, legal warriors, how to beat a DUI charge in Washington State. Do you ever wonder about that topic? Are you charged with a DUI? Is it just something you're interested in? If so, stay tuned because this is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years. And I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will get the help they need. Now I'm just going to jump right into it. How do we beat a DUI charge? There's a lot of factors that go into it. But if you're ever facing a DUI charge, these are some of the most important things to consider and most important things to do. Number one, you need to request a Department of Licensing hearing. If you blew .08 or more as an adult, or if you refused a breath test or a blood draw, or if you had 5 nanograms or more of marijuana in your blood, you're going to get a license suspension, and the officer should give you a form to request a driver's hearing. We really need people to request that driver's hearing so we have a chance to subpoena the police officer to the Department of Licensing hearing, which is all about whether or not they did things correctly. But guess what? We have the right to subpoena that police officer to the telephonic hearing, and that police officer is under oath and has to testify without any prosecutor there to help them. They're stuck with the answers, and sometimes those answers are gold. I can think of many cases where my firm has used the answers that a police officer gave to actually defeat the case. I remember one case that was on Halloween, and somebody was dressed in something with costume blood, and the officer testified, and we actually had a tape also that showed that the client had put his or her hand in their mouth with that costume blood in their hand, and that was a foreign substance which invalidated the test, yet the officer swore under oath that never happened. We had the tape, we had the officer swearing it never happened, and that really played a big factor with the prosecutor in getting them to let us beat that DUI charge. So it's important to request the licensing hearing. It might have turned out totally differently if the people that we worked with in that case did not request a licensing hearing. Okay, so what's the second thing that we need to do to try to beat a DUI charge? Well, you just heard me mention it. Get the tapes. Most of the time, if there's a breath test in a DUI charge in Washington State, there's going to be some type of video in the breath test room. Now, there's not going to be audio typically, but there's going to be video. And the officers have to do things a certain way. In that prior example I mentioned, there has to be a mouth check where the officer asks if there's something in your mouth or looks in your mouth to make sure there's nothing there. And then the officer has to watch the driver the entire time, making sure they don't vomit or put something in their mouth, like their own hand even, okay? And so the only way we're going to try to get that evidence to see what happened is if your attorney asks for it. And usually it wastes, it gets recycled. Usually it's on a DVR, digital video recorder. It might only be there for a couple weeks. So hopefully whatever attorney you retain to help you will request to preserve and obtain a copy of any videos from the breath test room. Also, we can try to get videos from body-worn cameras. Sometimes they're out there. Those will usually be preserved. And state patrol videos, like for the stop. I can think of a case where our firm has used the state patrol video to challenge how the police officer stopped a client. The police officer saw the client swerving, they claimed, but yet on the tape there was no swerving. So we got that video, we played the tape, and that case went away. So it's really important in beating a DUI charge that your attorney try to get every piece of evidence because you never know what's going to help, and the tapes will often help. So how else can we beat a DUI charge? Well, we want to take a look at the field sobriety tests and how they were instructed. Okay, it's tough to challenge how they are scored, but as you may or may not know, there's 3 field sobriety tests in Washington State. There's a horizontal gaze nystagmus, where they check our eyes. There's a walk and turn test, which is 9 heel-to-toe steps down an imaginary line usually, and return taking 9 heel-to-toe steps. And there's standing on one leg. Standing on one leg for a period of time and counting 1001, 1002, and so forth. And so usually there's not going to be a video about how those tests were scored by the officer, but oftentimes there's going to be at least an audio of how the officer instructed those. And guess what? They're standardized. So if the officer didn't instruct them correctly, then they shouldn't be used against the driver. And what's the only way we're ever going to find out how the officer instructed? Well, get a tape from the state patrol vehicle, from the Seattle Police Department vehicle, where we can hear how they instructed them. Occasionally we can get an officer to make a mistake on a licensing hearing about how they instruct things, but it's less powerful than having the actual tape. So if field sobriety tests, which is mainly the main basis for an arrest in a DUI case, if those aren't instructed properly, perhaps we can use the fact that they weren't instructed properly to beat the DUI charge. So that's really important, that we want to take a look at the field sobriety tests. The next thing we want to cover, number 4 here, is how was the breath test administered, right? Was the breath test done properly? That's where I need to look at that tape. Several things need to happen there. The officer has to check someone's mouth. The officer has to observe them for 15 minutes prior to the test to make sure that there's nothing put in their mouth and nothing comes out of their mouth like vomit, so to speak. And also, the breath test has to be performed properly. It has to give certain numbers. And if there's an invalid test or an incomplete sample, certain things need to happen. So we need to see, was the breath test done properly? And part of that is if the driver asked to speak to an attorney, like a public defender or their own private attorney while they're under arrest in the breath test room, did the officer give them privacy? Was the officer listening in? If the officer is listening in and the driver is asked for privacy, then that could violate their constitutional right to an attorney, and we can beat the DUI charge that way. So all these factors, DUI charges aren't hopeless. There's so many things we can look at to try to help beat that charge. We can also pull breath test machine records. Right now, there's big challenges going on to the Draeger machine in King County, Kitsap County, other counties where breath tests prior to November 7, 2022 in some counties are subject to suppression right now based upon records of the machine and how the machine performed. And that's broad, but there's also specific things we need to look at about how the machine performed. So those breath test records your attorney will get and take a look at. They're available right in the Washington State Patrol website to see how that machine was operating if the machine is the one saying that the driver is guilty. We can also take a look at what was the basis for the stop. I mentioned that earlier, the basis for the stop. Was it a legal stop? Is there a complaint that somebody used bright headlights and I pulled the person over for bright headlights, but maybe the report doesn't say that the bright headlights were within 300 feet of them, because it's not illegal to use your brights on the road. It's illegal to use your brights on the road within 300 feet approaching a vehicle or 500 feet of another vehicle coming your way. So if that's the only reason for the stop, perhaps it's not a legal stop. There's also a case called Ladson out there where it says, hey, if an officer is sitting outside a bar, so to speak, and they're just pulling everyone over coming outside the bar, and they wouldn't normally do things like that, it's a little more complicated. But if it's sort of a pretext stop and we can get the officer to admit to such, and sometimes we have, believe it or not, then we could get that stop suppressed. And if the stop is suppressed, we beat the DUI in most cases. Additionally, there are cases where you're in a traffic accident and maybe the car is not registered to you. Well, if the car is not registered to someone, there's a traffic accident, and the officer hasn't seen that person drive, then there's a theory of the law where we can't use admissions that we were driving against a driver unless some other evidence ties them to the car. It's called Corpus delicti. Think about it this way. If I were to say I murdered Mr. X, they wouldn't be able to prosecute me for murdering Mr. X unless they could show a Mr. X existed and he was either dead or missing, because we can't prosecute people just for their words if there's no underlying evidence of a crime on top of it. So that's another thing we can look at. If we have a traffic accident type DUI situation and no one saw the person drive, is there enough evidence to tie them to the car to use their own admissions of driving to prove they were driving? Because most people say, yes, I was a driver, but the question is, can it be proved? I think one of the final things I want to cover in how to beat a DUI charge is, of course, the actions of the client. The more actions a client does after the charge, an alcohol evaluation, follow up with any treatment, those type of things, the more actions they do, the more power our legal arguments end up having with the prosecutor. Remember, it's not the prosecutor's job to let us go, it's the prosecutor's job to respond. If there's a really challenging fact pattern for the prosecutor and the client has done some stuff for like a normal DUI type stuff they would do anyway, alcohol evaluation, follow-up DUI victims panel, then it's more likely that that prosecutor will say, well, at least there's been some response. I don't want to fight this all the way to the end. I don't have enough time and I'll probably lose. So I'm just going to let them go. So many ways to beat a DUI charge. And of course, the traditional ways are, don't have a breath test over the limit. That helps, although they can still try to convict you. Don't get in this situation to begin with, but I hope this has been helpful. There are plenty of things we need to do to help beat a DUI charge. And you notice most of them are getting on things right away, getting that qualified attorney who knows how to do all the things they need to do, and then doing what the attorney asks you, stay positive, and hopefully there's a great chance that that DUI charge can be beat. So if you found this useful, please like and please subscribe because more people will get to see it. And actually, if you need legal help, feel free to reach out to my firm. Again, my name is Lance Fryrear. I've got a law firm in Linwood. We've been defending people charged with crimes for more than 20 years. We'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.